Luigi Mangione has a new defense. What does it mean? Will it work? And if it works, what will it mean? May it please the audience, I'm Rich Schoenstein. Welcome back to So Sue Me. I haven't seen you in a few weeks. I've been off doing some trial work myself. Pretty good time, but enough about that. We're going to talk about major developments in the Luigi Mangione case. Yes, I know it's not civil litigation. This is a podcast about civil litigation. Bear with me. All right, here's the big reveal today at the state court pretrial conference that was held this morning. Luigi Mangione will assert psychiatric defense in murder case in United Healthcare CEO's killing. So, what exactly is the defense and what does it mean? Apparently, Mangione is going to assert a defense called extreme emotional disturbance. And let me tell you right now, that is not an insanity defense. That is not arguing that you're insane and therefore can't be held responsible for the crime at all, which we all know is an extremely difficult defense to prevail upon. That's not what it is. Under New York law, extreme emotional disturbance is a defense that, if successful, allows you to reduce a murder charge to a manslaughter charge. So the murder charge here is second-degree murder. Remember, it was first-degree murder, but the defense got the first-degree part dismissed because they got rid of those terrorism-related charges. So it's second-degree murder. The maximum penalty is life in prison with the possibility of parole. It could get reduced further on this extreme emotional disturbance defense to manslaughter, with a sentence up to 25 years or less with opportunity for parole. So, if successful, it could substantially reduce the total amount of prison time Luigi Mangione would face, which is important, especially when you're dealing with a young person like he is. He could, in theory, get back out sometime in his 40s or maybe even earlier if this defense is successful. Now, what is extreme emotional disturbance defense? I pulled this off of the court's website. You can easily find it if you just use the old Google or whatever search engine you like. But basically, there are three components to this defense. First, the defendant must have had an extreme emotional disturbance. That is, the defendant must have had an emotional disturbance so extreme as to result in and become manifest in profound loss of self-control. Second, there must have been an explanation or excuse for such extreme emotional disturbance that was reasonable. The reasonableness of that explanation or excuse must be determined from the viewpoint of a person in the defendant's situation under the circumstances as the defendant believed them to be. Third, in committing the homicide, the defendant must have acted under the influence of that extreme emotional disturbance. Now, a few other things about this defense. It is a defense. It is the defendant's burden. Remember, in a murder case or any other criminal case, it's the prosecution's burden to prove beyond a reasonable doubt guilt. But this is an affirmative defense, and it becomes the defendant's burden to prove it by a preponderance of the evidence. That's one. Two, they don't need expert psychological testimony to put on this defense, but it helps. And it appears, based on the hearing this morning, that the defendant does have an expert witness who's going to testify to this extreme emotional disturbance and therefore going to offer some proof on that. Third, you can have the defendant testify on a defense like this, but it isn't necessary. It's not like self-defense, where you really need the defendant to stand up and say why he felt he was in danger and why he did what he needed to do. If you're arguing someone is emotionally disturbed, you actually have a pretty good excuse to not put them on the stand, and I would continue to think Luigi Mangione would not be on the stand. So, how does this change the trial? Well, I think it changes the trial significantly, and it changes the feel of this case, and I think it maybe allows the defense to put the insurance industry on trial. Let me explain what I mean by that. The sense of this case is that Luigi Mangione had some interactions with the insurance industry that did not go well, that he became very upset about the insurance industry. He wrote at great length about the insurance industry. And the alleged murder of Brian Thompson was an act manifested out of that upset at the insurance industry. If the defense pursues the extreme emotional disturbance defense, then they get to, and in fact are obligated, to put on the explanation of why Mangioni suffered an extreme emotional disturbance. And that would allow them, in theory, to put on whatever his interactions with the insurance industry were. He might even get to use that notebook or manifesto affirmatively as proof that he was emotionally disturbed because of all the stuff he wrote about the insurance industry. And in telling the story of why he was emotionally disturbed, you're also standing up and saying to the jury, in effect, he was emotionally disturbed because this is how he was treated by the insurance industry. And ladies and gentlemen of the jury, wouldn't you be emotionally disturbed too? This is a way for them to put the insurance industry on trial during the trial of Luigi Mangione. And when it was first announced they were going to pursue this defense, my immediate reaction was that this was sort of contrary to Luigi Mangione's story. Luigi Mangione supporters, as we call them, have been saying he's a hero. There are loads of people out there. I mean, there are 40,000 people who have contributed money to his defense. $1.5 million at least have been contributed. There are people that say, I think he did it. I think he killed this man, but he was justified in doing so because he was sending a message. And I've pushed back on that. I don't agree with that. I don't think that's the way to send a message, and I don't think it condones murder, and we could go on and have a debate about that. That's not the purpose of this discussion. But there are those supporters out there, and I thought it was odd that Luigi Mangione would now stand up and say, no, I'm not a hero. I'm extremely emotionally disturbed. I wasn't acting to better the system. I was acting because I have this mental condition that has been brought. But the more I thought about it, the more I've realized he's going to say that the reason for that extreme emotional disturbance is the insurance industry. And in that way, it becomes more consistent with the story that he's been telling. In fact, it becomes very consistent with the narrative that something happened to him, he became egregiously upset, and he took action into his own hands. And he's now going to go to trial, and his legal team is going to say, yes, that's exactly what he did, and it has consequences in that he has a partial defense that should reduce the severity of the crime he is convicted of. Let's talk about that for a minute, because that's interesting too. If you're going to pursue this defense, you're basically conceding that he did it. You're basically telling the jury, yes, we agree, the proof is there that he is the man who murdered Brian Thompson. And maybe the defense thought they had to do that based on the evidentiary rulings in the case. The judges letting the gun into evidence, the judges letting the silencer into evidence, the judges letting the notebook into evidence, the judges letting some of his statements at the Altoona McDonald's into evidence. And maybe the defense thought that was insurmountable, that they couldn't put on a reasonable doubt case that would completely exonerate Luigi Mangione because of the volume of evidence and the substantialness of the evidence that's going to be put in at trial. I would understand them thinking that. But it does eliminate the possibility. The other thing we've been talking about since the beginning of this case is jury nullification. The idea that if he got just one juror on the panel who was dead set on acquitting him, it would prevent a conviction. You're kind of taking that off the table now. You're kind of saying we expect a conviction, and now we're only talking about the degree of that. And think about that some more. The defense has been successful in this regard. When you have a person who has been accused of a capital crime, your first job is to keep them alive. Check. The defense has already done that. They got the death penalty eligible crimes dismissed in the federal case. That's off the table. Next, you're trying to give your defendant an opportunity to be out of prison sometime in his or her life. Check. In the New York State case, they got rid of the terrorism charges, so the maximum penalty is life in prison, but with the possibility of parole, although down the road in the federal case, there's a without possibility of parole possible sentence. But in the state case, life with possibility of parole. So now they're looking to whittle it down even further. Let's whittle it down to a 25-year or less manslaughter conviction. How are we going to do that with this defense? What are we going to give up? We're going to give up any possibility of a complete acquittal. I mean, I guess statistically, there's still some possibility the juror would show up and vote not guilty, but that's going to be really hard to do in a trial where you're essentially conceding guilt. You're giving that up in exchange for the possibility of a much lower sentence, and a sentence that would afford Luigi Mangione the opportunity to be free while he still could be an adult. And I'm fascinated by the strategy of that. You know, I've said from the beginning, Luigi Mangione has a badass legal team. They are highly talented. They are in demand in the state of New York in these criminal cases. They are wildly good, and they have been very effective in his case by getting those charges thrown out in the federal case and the state case, by zealously representing him, the way they advocate on his behalf. Very effective. So I'm not here to second guess their strategy at all. I assume they're making good strategic decisions, but make no mistake, it is a strategic decision. We're going to essentially concede that he's the guy that did it. This is no longer a who killed him case. This is a why case. Why did he do it? He did it because he was suffering from extreme emotional disturbance. Why was he suffering from that? The insurance industry. The insurance industry, the insurance industry. And we're going to show you what the insurance industry did. We're going to show you what he wrote about the insurance industry. We're going to show you that a reasonable person could have become extremely emotionally disturbed, that he in fact did, and that's what led to the crime. And they can mesh that with the idea that he's heroic in some sense. I mean, they can't say he's a hero in court in front of the jury, but they can still ride that wave of public support that he's some kind of hero, that he's some kind of martyr. I don't know, he's the Robin Hood of the whatever you want to call him, whatever you want to say about him. Again, I don't agree with that, but that has been the voice out there. I think this is going to very much change the tenor of the trial. I was anticipating a trial where they challenge the proof, they challenge the investigation, they challenge the admissibility of the evidence, they challenge whether there's enough evidence that was really him. That may all be off the table. This is now going to become a why case. Why did he do it? And does he have a legal defense born out of that why, extreme emotional disturbance, that will allow him to reduce the sentence? It appears this case is going forward in September. There was some discussion this morning in court about schedule, and the judge made it pretty clear. We have September dates. We're going to start in September. They are in the process now of submitting proposed questionnaires for jurors. As we've said, jury selection in this case is going to be long and arduous. To find people who may have heard about the case, but nonetheless have an ability to remain impartial, to listen to the evidence, to listen to the judge's rulings, and to render a fair and just verdict. That's going to be a very long process, much longer than average because of the public outcry surrounding this case, and because of the possibility on both sides, right? The possibility that you could get jurors dead set on acquitting him. And by the way, the possibility that you could get jurors dead set on convicting him. And that's a problem for criminal defendants all the time, that jurors assume the police, if they arrested somebody, it's because they were guilty. And so the defense always has to worry about jurors who will convict no matter what. And now in this case, in these particular facts, the prosecution has to worry about jurors who will acquit no matter what. And you need to get rid of all of those no matter what jurors and get jurors who are going to listen to the evidence. And I think they'll be able to do it because we do it all the time, because New York City is one of the great jury pools anywhere in the world of smart, capable people who are dedicated to jury service, who want to render the right decision, who will put in the work. That is very much part of the fabric of New York City. You get that kind of hard-working, open-minded jury, and I think they'll be able to do it in this case. It's just going to take a while. This case is not getting any less interesting. I'm really glued in now on how this defense develops and how it changes the tenor of the case. Can Luigi Mangione turn this into a trial of the insurance industry? Let's keep an eye on it. I'll be back to talk about it more. Thanks again for watching. Sorry I haven't posted in a while, but sometimes work and life, and I had a lot of basketball to watch over the last couple of weeks, which was quite enjoyable, I must say. Go Knicks! Thank you all. Don't forget to like this video, subscribe, do all that stuff. We'll see you soon. For now, we are adjourned.